Well, I just want to point out that the Credit River decision is an excellent point to listen to, because there's the elements of law that are expressed there are done by somebody who's got a true interest in the people. You have elements of a contract. There's 4 elements to a contract that have to be in evidence. 1, there has to be a meeting of the minds. You have to know what you're bargaining for. If you don't know what you're bargaining for, how do you enter into a contract and call it legitimate? Let's say that you go over to your friend's house and he decides that he's outside washing his Cadillac, and he tells you that he'd sell you his car for $6,000, and he's got a brand new Cadillac, and you go, "Oh boy, that'd be great. I'll buy your I'll buy your car for $6,000." And then he says, "Okay, come in, sign the agreement." And you sign the agreement that he'll sell you his car for $6,000, and you sign it, and he goes around back and gives you his 1982 Toyota. Well, there was no meeting of the minds there, because you didn't think you were buying the Toyota. You thought you were buying the Cadillac. It was an assumption on your part, but because it wasn't spelled out in the contract, he can't really enforce that contract. No meeting of the minds or full disclosure. The second issue is you have to have consideration exchanged. Something of value has to be exchanged. You can't give away something of value and receive nothing in return. The law doesn't allow that to happen. It wouldn't be, nobody would believe that you honestly entered into a contract and you got nothing in return. So the thing that you're giving of value can be something as simple as your signature, or a promise, or giving up your rights in some way. The third thing is that you need to have 2 wet ink signatures. There has to be offer and acceptance. If you don't have 2 wet ink signatures between the 2 parties establishing both of them are giving something and sacrificing something, there's no liability if you don't sign your name to something, right? I mean, you get into any contract with anybody and you don't sign your name, the first thing they want is you to sign your name. If you don't sign your name, there's no contract. Well, look at when you get into a relationship with the bank. You went to the bank and you signed up for all the mortgage note and whatnot. Did you ever sign your name to the contract? Yes. Did they sign their name? Did an agent of the bank sign their name to the contract? No. The front page that I'm showing here is called Modern Money Mechanics, and it was written by the Federal Reserve Bank of Chicago. And if you go online and look up Modern Money Mechanics, you can read a PDF version of it. And in it, they spell out that the bank creates money from thin air. So you went down to the bank and you signed up for a loan to buy a house. Well, the first thing you did was you signed a copy of a promissory note and a deed of trust. Okay, the promissory note is a big fat check. It has all the elements of a check. It has a date, it has an amount due, it has who's getting the money, and it has the person who's paying the money. That's you. And the bank takes that promissory note and deposits it in an account. And when it deposits it in the account, it does exactly what they did in the Credit River decision. They just, by bookkeeping entry, deposit your check and create the funds that then they write a check to the seller for. Did they give the seller legal tender? What's legal tender? What's credit of account? What's deposit money? If you read the Federal Reserve's Modern Money Mechanics, it explains what all these different terms are. But legal tender is the green stuff with dead presidents on it, and they don't give the seller legal tender. They don't give they don't give legal tender to the seller. The seller does not receive $250,000 or whatever in Federal Reserve notes. What it gets is a check, and a check is not the same. There's only about 3% of the money that is truly money that has been advanced by the Department of Treasury and exchanged for Federal Reserve notes. The rest of the money is just money that's created from thin air, and you wonder why our economy is in such bad state and why there's so much greed today. It's just money that's created from thin air without any lawful authority. So they deposited that check in the account and then gave another check to the seller, and the seller's happy. He deposited his money and sold off paid off his bank or whatever. Now, do you owe the bank any money? Well, the bank didn't give you any consideration, as the Credit River decision shows. The bank didn't advance any actual consideration. Under the Constitution, did it give any gold and silver? Did they advance anything of value? Were there any valuable assets presented by the bank on your behalf? No. The only valuable assets that were gotten are the ones that were gotten from you by your signature, which is extremely valuable. So anyway, they created a note, a promissory note, and that promissory note gave them the authority, along with the deed of trust, to take the property, which is your home. The note gets sold off by the bank, and when the new buyer of the note gets the note, it actually pretty much disappears. If you ask the bank to produce the note these days, they can't do it. They've sold it and they've gotten paid. Not only do they get paid once, twice, 3 times, they can create up to 30 times or more the amount of money based on the amount of money that they have on their assets. So if they have your promissory note and your promissory note's $250,000 and they can create 30 times that amount to loan out to other people, how much money are they making? It's inestimable. Anyway, the bank then no longer has your note. So if they don't have your note, they don't have the agreement between you that they can enforce, and they have no enforcement rights. So Eric's going to read from you from a decision by Thomas Rose in 2007 that basically verifies that.
And I also wanted to state that when the note is sold, sometimes it's also bought as an investment by various individuals or agencies or other banks, and it can be sold over and over and over and over again, and that's how we got the inflated, part of how we got the inflated housing bubble that has recently burst, yeah?
And why would somebody buy that note? That note that note is considered a valuable asset, and it is traded for its fully realized amount, such as, let's say it's $250,000 to begin with, but over 30 years it'll be $500,000 or $600,000. Another bank will buy that note and put it on their books as a $600,000 asset, at which point they can loan out 30 times that amount. So now you see why they don't even care about the note. They care about making the loans for the huge amounts that they can hypothecate and create from that.
This process is a process that actually anybody could group together with friends and family and do in their living room if they know how to prepare the documents properly. The only problem is the banks get away with it, and when individuals in the community try to do something like that, they go to jail.
Well, we discussed before, is there any real difference between a counterfeit $100 bill and a Federal Reserve $100 bill? The only difference is the Federal Reserve has a sheriff who will go attach your body and send you to prison. The sheriff should have the same duty to attach the Federal Reserve person and put him in prison for counterfeiting, because there's no law that allows him to create that $100 bill.
The banking system, like the IRS and the Federal Reserve, are all three corrupt RICO-style criminal cartels. So, United States District Court, Southern District of Ohio, Western Division at Dayton, in a foreclosure case on the 15th day of November, year of our Lord 2007, Judge Thomas M. Rose stated here, to satisfy Article 3's standing requirements, a plaintiff must show, 1, it has suffered an injury in fact, that is concrete and particularized and actual or imminent. The injury is fairly traceable to the challenged action of the defendant. And 3, it is likely, as opposed to merely speculative, that the injury will be redressed by a favorable decision.